that come before the court is Gearhart versus Nationwide Mutual Insurance Company.
May it please the court.
I was just going to tell you just some ground rules. You probably know it.
Yes.
You have 15 minutes and you reserve up to 5.
Thank you, Your Honor. I was going to ask that I could reserve up to 5.
Okay.
And,
You may proceed now.
all right, thank you. May it please the court. My name is James Matthew Linehan. I'm here on behalf of the appellant, Gearhart. I'd like to begin by just identifying the 3 different things I want to talk about today. First, the issue before this court. It's not whether or not the non-compete restrictions within an agent's agreement that Gearhart had with Nationwide is enforceable. That issue has been litigated before in the Ralston case and the Plazo case. And we're not contesting the enforceability of the non-compete agreement that Gearhart had with Nationwide. Rather, the issue before the court is when that non-compete may be enforced and how that non-compete may be enforced. And that brings me to my second point.
You mean the duration of the non-compete?
No, Your Honor.
Okay.
When I speak of when the non-compete may be enforced, I'm talking about the nature of this non-compete. Unlike most non-competes, this isn't a contractual provision, as the trial court noted, that really results in a breach that Nationwide could sue to get an injunction on or seek damages or liquidated damages. Instead, the nature of the agreement at issue, the non-compete, is a condition subsequent that results in forfeiture. And this is an important distinction because as a condition subsequent, what the agent's agreement does is the agent's agreement creates an entitlement in Gearhart. That is, he is entitled to about $500,000, yes, $500,000 in retirement money upon the cancellation of the agent's agreement. That money invests within him. However, Nationwide pays that money out over time so long as he doesn't violate the terms of this non-compete. That, as this court has recognized in Ralston and prior precedents, is a condition subsequent that results in forfeiture. And as a condition subsequent, it is subject to the law concerning forfeiture. Unlike conditions precedent, which is what we've heard oral arguments today about, and about the case law on which Nationwide relies on in its brief, a condition subsequent has particular rules that apply to it because it does result in forfeiture. And the law, under the Ohio Supreme Court precedent of Manhattan Life, holds that the law abhors forfeitures. Therefore, there are certain requirements that come into play. Specifically, 1, with a condition subsequent, this court has held previously in Brunner Goodhue that there has to be a material breach, that substantial performance of a condition subsequent is enough. And the record in this case reflects that there was no material breach of this agreement. Mr. Gearhart did have an office location within a 25-mile radius. I don't think there's any disputing that. However, he made a good faith effort to comply with every element of his non-compete.
I'm a little confused,
Yes.
I guess. You're talking about breach.
Yes.
But breach really comes into play when you're talking about damages.
Material breach is talking, when I'm referring to material breach or substantial performance, they're the two sides of the same coin. I'm referring to the violation of the condition subsequent itself.
I know what you're talking about. That's why I'm asking. Why are we talking about breach with a condition subsequent when we're talking about, because you're not really looking at damages, you're looking at forfeiture, like you just said, right?
Right, and because the law abhors a forfeiture, when you have good faith compliance with a condition subsequent, that is an effort to perform under the condition subsequent, then of course that you cannot, under these precedents of Brenner, Goodhue, and MVP, that is enough, certainly enough to get past summary judgment and enough to submit it to trial.
On the facts of this case, there was
Yes.
a set mileage limitation. And how can there be good faith compliance if that is not adhered to strictly?
Okay, so with respect to the non-compete provisions at issue, there were three. First off, there's one non-compete provision that Nationwide had no evidence of. That is that Gearhart was soliciting Nationwide policyholders. That is, people that had policies in force with Nationwide. There is no evidence of that. The people that came to him had already canceled on their own volition without Gearhart's involvement, without him directly or indirectly soliciting them to cancel their policies. They came to him and said, "Can you help us with insurance?" These were family members and very close friends. So, as the trial court noted, there was no violation of that provision. And then as for the other provision, that is operating as an insurance agent within a 25-mile radius of his former office location. In that respect, there was no material breach because Gearhart, as he testified, he didn't have an office sales location. When he created this office, it was originally supposed to be it was supposed to be an office location for his baseball coaching career. He's a former Houston Astros player. And it was functionally a mail drop that he rarely visited. It was just a location that he had. But setting that...
Is it a place with a door and a desk and a
Yes.
chair?
I haven't personally seen that, Your Honor.
So then would you say that he's working out of his house then?
I would say that's a fair assumption, or a fair declaration. I will say that I'm coming into this case later into it, so I don't know the exact frame, or exactly what happened.
It doesn't really matter except what's in the record.
That's right.
So is there anything in the record about where he worked at?
No. In terms of where he worked, there is nothing in the record. It's the office location. It's what the record reflects was that it was used as a mail location. As for...
Well, does he do business through the mail?
I'm sorry?
You said it was a mail location.
Yes.
I presume one does business through the mail.
Yes, Your Honor.
All right.
But this brings me to my second point, which was even if there is a material breach of a condition subsequent that results in forfeiture, the law is also clear that there has to be a demand for performance, or what we call a notice and right to cure. This is clear under Manhattan Life, an Ohio Supreme Court precedent. It's clear under Ivy. It's clear under multiple court cases. And granted, they are all old cases, but then the law concerning condition subsequence is rather old. There's also a notice and right to cure under what's called the VSIP agreement. It's a separate agreement that both Nationwide and Gearhart entered into after the agent's agreement. The VSIP agreement, I've actually got copies here, the agent's agreement and the VSIP agreement, they are separate documents. However, the VSIP agreement, what it did was it canceled the agent's agreement, thereby triggering the entitlement to extended earnings and so forth that are at issue in this case. And it preserved only that paragraph concerning the extended earnings and the retirement funds and the non-compete provisions, and then it incorporated them into the VSIP. And under the VSIP, under paragraph 16, it too provides Gearhart with notice and right to cure. And the record in this case reflects that prior to receiving any notice and right to cure, Nationwide terminated his extended earnings under the agent's agreement. It never gave him a real right to cure the material breaches, the alleged material breaches of his non-compete agreement. And the testimony also reflects that he did try contacting Nationwide. He did ask them, what should he do to correct this? They never responded.
Wasn't that in the letter that they wrote him in the first place, that he needed to move 25 miles away?
No. In fact, the letter stated two things. One, it stated that he was working for the Stefano Insurance Company, which, as the trial court noted, wasn't true. He wasn't. The second thing that the letter also stated was that he was soliciting nationwide policyholders, which was also not true. These were not nationwide policyholders with policies in effect with nationwide. That was what the agent's agreement prohibited. It didn't prohibit Gearhart from selling insurance policies to people who no longer had insurance policies. And so with respect to how he was supposed to cure this violation, according to the record, he did make a good faith effort before any of this started to find a location that complied with the non-compete agreement.
And you're starting your rebuttal time, by the way.
Thank you.
You can answer this question, but I'm just saying you're going to be in your rebuttal time.
Certainly. With respect to the notice itself, the notice itself was deficient, and it was also after the fact. At this point, Nationwide had already forfeited the payments under the agent's agreement, and therefore never gave him a real notice and right to cure, and therefore have no right to declare forfeiture. Thank you, Your Honor.
Morning, Your Honors. May it please the Court, Jim Shuck on behalf of the Appalachian Nationwide Mutual Insurance Company. I'm a little confused, frankly, by the presentation from Mr. Gearhart's counsel. At the beginning, he indicated that he seemed to admit that there was no dispute that Mr. Gearhart was operating within 25 miles of his nationwide agency. But then later on, he goes into this mail drop argument, the fact that it appears as though he's arguing the opposite, in which case that the new independent agency location wasn't really an agency, wasn't really an office. And so I'm confused, and so I guess I'm going to address the argument, the mail drop argument.
Can I interrupt with
Sure.
a question? I maybe don't understand the whole environment of this. If they have a 25-mile office restriction, does that mean that the former employee can solicit anyone as long as he's working a distance of 25 miles, he could even solicit present customers of his former employee?
Let me correct one thing. First of all, these agents are independent contractors, they're not
Okay,
employees.
okay.
I know that normally this arises in an employment situation. This is not an employment situation, but I do understand your question. It is in section 11F of the agent's agreement that is attached to our motion for summary judgment. It's the agent's agreement Mr. Gearhart signed in 1993. And it reads, all liability for Nationwide to pay agency security compensation shall cease and terminate. It uses those terms, shall cease and terminate. In the event agent does, and then goes on to list 3 different things that the agent can't do. The trial court based its decision on one of those, and I believe that is the correct decision. It says nothing about necessarily soliciting policyholders of Nationwide. It says that the agent shall not engage as an insurance agent within a 25-mile radius of his nationwide agency. He shall not be licensed as an agent within 25 miles of his insurance agency. He shall not in any way be connected to the insurance business within 25 miles of his insurance agency. That was the language that was affirmed by Ralston, and Your Honor was on that panel in Ralston 10 years ago, as well as Plazo.
I do remember it.
Yes.
I don't.
You were on the panel, and in Plazo as well in 1996. So that language in F1 that's the basis for the trial court's decision says nothing about soliciting policyholders or former policyholders, or whether they're existing or current or former policyholders. It just says, are you licensed to do business, and are you doing business within a 25-mile radius of your former nationwide agency?
So if his office was outside of the 25 miles, he could poach former clients or poach existing clients.
I believe that then that would go to F3, 11F3, which I believe prohibits him from writing policies, replacing policies, nationwide insurance policies, with policies written by other companies. So you can't do anything within 25 miles. You can move outside 25 miles and for 1 year not solicit nationwide policyholders. And many agents do that. In fact, this is an election. This is really not an issue, as Your Honor indicated, not an issue of breach, This is not an issue of a promise, and this goes back to first year contracts, promise versus condition, and we all learned this first year of law school, what the difference is between a promise and a breach. If it's a promise, it's an absolute obligation to perform there. If you don't, arises breach and damages. And here you have an issue where it's not a promise to perform, but a condition that discharges Nationwide's obligation. So if the agent chooses to perform, chooses to compete, Nationwide has no right to come in and seek injunctive relief, file a breach of contract claim, seek damages. They're just merely excused from paying agency security compensation. So
it's not necessarily spoken of or reviewed in terms of breach, but nonetheless, there can be issues of fact as to whether or not this
correct,
occurred.
correct, Your Honor, and I want to address those. And I will say to you, the question was, to my opponent was, is there evidence in the record? Oh yeah, there's tons of evidence in the record. In fact, the record's pretty clear on this. Page 29 of Mr. Gearhart's deposition, he testifies his Nationwide agency location was located at 2680 North Haven Boulevard in Cuyahoga Falls. It was page 29 of the deposition. Pages 6 and 38 of his deposition. He says, after I left Nationwide, I didn't do much for a couple months, but then I went over to DiStefano, and he has a lease, and the lease is attached to our motion for summary judgment into a 5-year lease with me, Mr. DiStefano, to sublet space at $500 a month. And that's, again, in our motion for summary judgment attached the lease. And he testified at page 6 and page 38 of his deposition at that location, 2036 Locust Street, Canal Fulton. We then offered an expert, Dr. Mark Salling of Cleveland State University, who's a GIS expert there, who came in, and believe it or not, you wouldn't think you would need an expert, but we offered an expert to say it's 18 miles from point A to point B. If you draw a radius around 2680 North Haven Boulevard, that 2036 Locust Street is 7 miles within that radius. This isn't a minor breach issue or a material breach issue, 7 miles inside of that radius. And that's attached to our motion for summary judgment. It's also attached to our brief in this case. We wanted to make sure the court was aware of it. So that affidavit and that expert report by Dr. Salling was unrebutted, unrefuted. So, this whole mail drop argument was something that was brand new, frankly, in the Court of Appeals. It was never raised below. And it's belied by the undisputed evidence in the record. And in fact, I'll show the court, we have 100 pages. We subpoenaed Safeco Insurance and have 100 pages, and this is attached to our motion for summary judgment as well, where on each of these, Mr. Gearhart's name and then the address of 2036 Locust Street is on deck pages with other insureds, on billings, commission statements. As to Safeco Insurance, Mr. Gearhart represented Safeco that he was operating out of 2036 Locust Street, Canal Fulton. So this was in the record as well. So we believe the record is undisputed that Mr. Gearhart was operating within the 25-mile radius. I do want to address, though, the materiality issue quickly. I do think that there's been some confusion on materiality and substantial performance. I think Judge Carr is correct. This is a condition issue, not a promise. So materiality, minor breach, substantial performance do not apply. And I think that what's the confusion is that the restatement does provide for a court to excuse a condition under certain circumstances. And this is not cited on a brief anywhere, but I did want to bring it to the court's attention. Restatement second of contract, section 237, and it's note D in that section 237. And it talks about substantial performance in the nature of conditions. And it says, it goes on to talk about if you have a constructive condition, a condition that arises by law.
Counsel, is that in your brief?
It is not in my brief.
Okay. You're really not supposed to argue things are not in your brief.
Okay, well then I would just direct the court to section 237. But what is in our brief is a reference to the Farnsworth treatise. And in that treatise, he makes clear that express conditions must be strictly and literally complied with. And so while this argument of substantial performance does arise at times where you have an implied condition or condition arises by law, where the parties agree in an agreement that they have a condition to payment, and that condition doesn't arise or takes place, then there's been a discharge. And it says, if the occurrence of a condition is required by the agreement of the parties, rather than as a matter of law, a rule of strict compliance traditionally applies. Then he was on to cite Professor Wollaston's treatise. Since an express condition depends for its validity on the intention of the parties, it has the same sanctity as a promise itself, and though the court may regret the harshness of such a condition, as it may regret the harshness of a promise, it must nevertheless generally enforce the will of the parties. And so that is cited in our brief, it's section 8.3 in the Farnsworth Treatise. That is the law.
So you're saying that equity wouldn't have any play whatsoever?
Correct.
Because it could be one insurance contract that he did for his mother,
Correct.
and he would lose $500,000.
Correct, and that's why at the end of the day, the law is that that's the deal that the party struck. And that's, again, we come back to, many times the condition is a third-party condition. It happens outside of the happening of a time condition, and it happens outside of the party's doing. This is a situation where Mr. Gearhart had the keys to the $500,000. He had the keys. He just had to move outside of 25 miles and not solicit our policyholders or sell our policyholders for a year. He did both. And while he may dispute F3, there is no dispute as to F1, Section 11 F1 in the agent's agreement. He was within 25 miles and he was licensed and acting as an insurance agent within 25 miles. His own testimony says so. His own, so I don't know that this is, even if material or minor breach or substantial performance apply, I would argue this doesn't apply. And in the trial court's decision, the court cited a couple of cases, one from the 8th District, one from the 10th District, that said that when we're talking about constructive condition, or excuse me, express conditions in a contract that deal with non-distances and that sort of thing, the courts have never said that substantial performance is sufficient, or that there can be a minor breach of that or a trifling breach. The distance is the distance, and everybody's presumed to know it. And using MapQuest to say you're going to turn left and go a couple miles and turn right and go a couple miles, nobody believes that that's fair when we're talking about a 25-mile radius. And the language in the contract was 25-mile radius. So you take a point and you put 25 miles around, and that's something that's objectively verifiable. And then lastly, on the notice and cure issue, there's no notice and cure provision in the agent's agreement. None. Didn't come up in Ralston, didn't come up in Plazo, hasn't come up in any other case that has ever dealt with this issue. It's just not there. He is attempting to co-opt a notice and cure provision from a completely different contract the parties entered into. That visa, we call it the VCIP agreement. And to be clear, the VCIP agreement makes clear that Section 11 of the agent's agreement, where the ASC provision in it is the right to ASC, is not superseded or modified. That's the language in Section 3, I believe, of the VCIP agreement. That the agent's agreement is not superseded or modified. They're two separate standalone agreements. Not incorporated. Again, this is another argument where Mr. Gearhart has gone back and forth. Below he said they were incorporated. In his brief here he said they weren't incorporated, and now it appears today they're back being incorporated again.
Does the fact that it's a standalone agreement mean anything?
I guess from what it doesn't mean anything to me, but I understand their argument to be they have got to get a notice and cure provision, right? That's their argument. That's the only place to find it. But there's no, to me, reasonable interpretation of the agreements that would say the notice and cure provision in a completely separate agreement. One was signed in 1993 and the other one was signed in 2010. They're 17 years apart. And as the trial court said, unless the subsequent agreement intends to incorporate that prior agreement, it doesn't. It's got to specifically say that they're merged into one another, and it doesn't. And in fact, the cure provision in Section 16 of the VCIP agreement says, any right to cure for breach of this agreement, it references this agreement. The right to cure is in this agreement as it relates to benefits under the VCIP agreement. No reference at all to the agent's agreement. And I do have one final point, Your Honor. You mentioned, Judge Schaefer, wasn't the cure letter, again, there's no right to notice and cure. But I guess if you found that there was, it says, and this is in the letter, I think what you were referencing, Ms. Ward's letter to Mr. Gearhart, where she says, stop violating contracts. She says, in order to cure this material breach of your VCIP, of course she's referring to the VCIP, there's no right to cure in the agent's agreement. But if what they're saying is we should have had the right for notice and cure, it says you will need to cease working as an insurance agent within a 25-mile radius of your former agency location and provide proof of same to nationwide satisfaction. That was the cure right there. So when he says, I was waiting for Nationwide to tell me what to do, it was right there. Simply sticking your head in the sand and saying, I wrote a letter. Well, the email actually said he denied that he was violating the agreement. There was no argument. He didn't say, I'm going to move. He didn't say, and this is in pages 48 to 50 of Mr. Gearhart's deposition transcript. The question was put to him, did you do anything different when you got this letter? No, was the answer. Didn't move, didn't stop what he was doing, didn't hang up his license, didn't do anything. And he said, well, I expected a phone call. Well, the letter came and it told him, move outside of the 25-mile radius. And he didn't do it. And so there's no right to notice and cure here in the agent's agreement. But if for some reason the court were to find that there was notice and there was no cure, denial is not a cure. Denial that I'm not in breach of the agreement is not a cure. So if there are any other questions, I'm happy to answer those, but that's all I have, and we would stand on our brief.
Thank you.
There's a couple of things that I want to address. Counsel for Nationwide is very good at pointing at something that we can all agree on and then arguing something else. Specifically, as to the issue of there was never any notice or right to cure provision. It was never addressed in Ralston, Plazo, or any of the prior Nationwide cases. It's because it was never raised. The parties never raised this issue. They never fought when and how these enforcement agreements, these conditions subsequent that result in forfeiture, may be triggered and how they must be enforced in order to declare forfeiture. They simply said, these are not enforceable. We're not arguing that here. That's not the issue. The difference between all of the authorities cited by Nationwide and the authorities that we cite is that all of the authorities respecting conditions, including Farnsworth, including all of the cases cited in Nationwide's brief, pertain to conditions precedent, which can create a contractual obligation. They don't result in forfeiture. They're not subject to the law of forfeitures. Whereas here, we're dealing with condition subsequent, which results in forfeiture. Therefore, the law concerning forfeiture applies. And whether or not the VSIP, or the agent's agreement is incorporated into the VSIP, there is a notice and right to cure or an obligation for Nationwide to issue a demand for performance, and that demand has to be made before the forfeiture is declared, and it has to be an effective demand for performance. And Ken Ward, the witness for Nationwide, admitted that she had no knowledge of how Gearhart could have actually performed after opening up this office, how he could have cured his non-compete. But nonetheless, she admitted that he did try to cure, that they simply didn't respond. And as to the issue of this office space, it's the testimony on page 42 of Gearhart's deposition was, well, did you have an office sales location? The answer was no. It was only later that counsel for Nationwide asked him a triple-barreled compound question, did you ever move your office location? Did you ever move, so you never moved your office location, stopped writing insurance policies or taking mail from that address? And he said, correct. This is an older gentleman who's being asked a compound question. It was an improper question that he'd already effectively answered.
Counsel, I'm just thinking about that demand for, that you said to cure.
Yes.
And I'm just wondering, because I'm thinking, isn't that just ripe for abuse? I mean, somebody could enter into one of these conditions subsequent and say, oh, shoot, I'll just take my chances because they have to give me a chance
Sure.
to so they could make $1 million and risk a $50,000 forfeiture would be.
Sure. So the issue in this, this is where we have to look at the law of equity concerning conditions subsequent. Because in this case, Gearhart was trying to comply with his non-compete agreement. He looked at it. Then he went to MapQuest before ever selecting an office location. He looked at MapQuest. It said he was outside 25 point, I think it was 8 miles. And this is not a geologist, this is not a topographer, he's not an expert. He looked to see how far out he had to be. He found a location that was close to his home, but at the same time outside the restricted area. He was trying to comply. He didn't go out and solicit current policies from, or policyholders of Nationwide that had policies in effect. He didn't try to act as an insurance broker within that area. He had an office location. And yes, the office location was a mail drop for these insurance policies. I don't think there's any disagreeing with that. But as to him trying to comply with these non-competes, he was trying to not comply.
Well,
with
I was just asking in general, if that's the state of the law, to
Sure.
me, it seems like it's ripe for abuse, because then if you have to give a notice and an opportunity to cure, in the interim, you could have done a lot of damage to a company.
With respect to,
And you're out of time, actually. I'm sorry.
oh, well, did you want me to answer your question?
Well, I asked, no, that's fine.
Okay.
The court will take the matter under advisement and will issue a written opinion to both sides, and it will be sent to you as well as on the website. Thank you so much.
Thank you.
for your time.